Welcome everyone to this property nuts and bolts webinar. It's the third in our Chambers series. A few headline points first of all of your microphones are automatically muted, so you don't need to adjust any of your local settings. We love getting questions throughout the course of the session, but please submit them via the text in the Q&A section, which can be found at the top or the bottom, confusingly, of your screen. And if you would like to remain anonymous when asking a question, please make sure you tick the send anonymously box before posting your question. We'll endeavour to answer as many of those as there is time for at the end of the three presentations. This webinar is being recorded. You will apparently receive a link to the presentation tomorrow at some point tomorrow after this event concludes. If your connection is lost at any point during the webinar, you can rejoin the meeting by clicking on the original link once more. So today's webinar will focus on residential service charges, which is a thorny and complex area of property law. The service charge is a deceptively simple concept. Most long leases impose on landlords obligations to carry out works or supply services to a particular building or estate, and the service charge is simply a contractual right for a landlord to recover its costs of doing so from the leaseholders who benefit from those works and services. But the catch is that over the decades, successive governments have interfered in private contractual arrangements between landlords and tenants with various statutory schemes, ostensibly to protect tenants from unreasonable or excessive service charge demands. And what that means is that this particular area of law is complex, difficult to understand, and ripe for lots of creative lawyering on behalf of landlords and tenants. And your speakers today are three such creative lawyers. Sophie Gibson is a property barrister at Landmark Chambers whose practice centres on landlord and tenant, both resi and commercial. She's acted on more residential service charge cases in the first tier tribunal than she cares to remember. She's also on the editorial board of the Housing Encyclopedia and has written passages on the Renters' Rights Act, which will be very shortly published. She's going to be in the Supreme Court later this year on the right to manage and statutory interpretation, and she has twice made oral submissions in the Court of Appeal on similar issues, winning once. And when she needs a break from practice, she teaches landlord part-time at the University of Cambridge. Harley Ronan, or Dr. Harley Ronan, to give him his full title, has a practice which encompasses all aspects of the law relating to the use and development of land. He's regularly instructed in property disputes all over the country, including apparently a trip yesterday from London to Carlisle and back safely in a single day. He's on the editorial board of the Encyclopedia of Housing Law and practiced together with Sophie and others in Chambers. In 2024, he appeared in the Supreme Court as junior counsel for the appellant in the A1 Properties Sunderland Limited and Tudor Studios RTM Company Limited appeal, and that's now the leading case on failures to comply with statutory procedures involving the acquisition of property rights. And critically, in what he omitted to mention in the biography that he drafted for me earlier today, is that he has a PhD in property law. My name is Tom Morris. I'm a specialist property litigation junior at Landmark Chambers. I will be chairing the session today and giving one of the talks. My practice is a wide one encompassing most aspects of residential and commercial property disputes. Service charge litigation has featured quite heavily in my diary over the last 12 months. I've been involved in 3 service charge appeals in the Court of Appeal. And it always amuses me to think that once upon a time, English contract law tended to be made by shipping cases, whereas more recently, it is increasingly made, it seems to me, through service charge disputes. There have been 3 major service charge appeals in the Supreme Court over the last decade or so. I'm endeavouring to have control of the slides and move to the next, but I'm not sure that I am able to do that. So can I call up the next slide? See if that happens remotely. And I think if we can carry on, great. Right, pausing there. The first case, which was in 2015, is well known. It's everyone's go-to case for a summary of the principles applicable to the interpretation of contracts. That was argued by Timothy Morshead of King's Counsel of Landmark Chambers. Then more recently, if we can move on to the next bit of text, there was an important case in Sara and Hussein Asset Holdings Limited and Blacks Outdoor Retail Limited. This was about the finality of certificates required by leases. And if we can go on to the next bit of text, More recently still, the decision in Aviva and Williams, which was argued by Landmark Chambers, Simon Allison, KC, and Brookline, which was about contractual obligations to act reasonably, amongst other things. And if we can go on to the next slide, this is what Lord Briggs said at the beginning of his judgment in Aviva. So the levying of service charge by landlords under leases of residential property in respect of their expenditure upon repairs and the provision of other services has for long been controversial. This is both because of its propensity to generate disproportionately expensive and time-consuming litigation, and because of the tendency of some landlords to seek to minimise risk by the imposition of contractual restrictions in residential leases upon what would otherwise have been the tenant's rights to have disputes about service charges resolved in court or in an appropriate tribunal. And one thing that all practitioners know about service charges is that they remain controversial. So if we can go on to the next slide, this year alone there have been at least four cases in the Court of Appeal concerning residential service charges. The first is Bradley and Rhodes versus Abacus Land 4 Limited. That's a case in which I acted for the successful appellant landlord about contractual obligations to act reasonably. The second case, Spender and FIT Nominee Limited, is a case where Simon Allison, KC, and I resisted an attempt by leaseholders to introduce a new test of statutory reasonableness under long-term contracts. The next case, Adriatic Land 5 Limited and long leaseholders at Hibberley Point, is a case about whether the service charge provisions in the Building Safety Act have retrospective effect. That was argued by Landmark Chambers, Simon Allison, KC, and Matty Green, and that is off to the Supreme Court later this year. And the final case, Cloisters Business Centre Management Company Limited and Anvari, is a case about whether a lease of a live-work unit in Battersea, which is used for storage, is a lease of a dwelling enjoying the service charge protections of the 1985 Act. I acted in that for the respondent tenant, and we will know when judgment is handed down at 10:30 tomorrow morning whether the tenant was successful or not. So watch this space. So having given that brief introduction to service charges and its importance to English law, I will now hand over to Harley, Dr. Ronan, who is going to talk about contractual machinery.
Thanks, Tom. I'm just going to double check I have control. I think I do. Thank you very much, Tom. Thanks everyone for attending at 5 o'clock on this gloomy January day. I'm going to speak on contractual machinery, as Tom's indicated. And I really do want to begin with the nuts and bolts of a service charge, excuse me, which, as Tom has already said, fundamentally is a contractual obligation on the part of the tenant to pay towards the costs of maintaining and managing the building. And for many of you, I suspect service charges will be familiar. So sorry if that's stating the obvious. But for those of you joining who are new practitioners moving into this sphere, don't do very much of it, it really can't be overstated the importance of bearing in mind that a service charge is a contractual right. So while also all of the statutory regulations about reasonableness and some of the other matters that Tom mentioned and that Sophie will be talking about as well, those are all well known, and they're particularly well known to clients who will cite them at you and throw them at you. But you can't forget the basic contractual position. In particular, what costs is the tenant actually liable to contribute towards as a matter of contract law? And again, for those of you new to this area, a service charge isn't an automatic right. It's not something that follows as a normal incident of the landlord and tenant relationship. It's something that the lease as a contract has to expressly provide for. So your first question really is, well, what do I have to pay for as a tenant? Or what is the tenant liable to pay for from the perspective of a landlord? You then get related questions about apportionment. If there is a obligation to pay towards the landlord's costs, well, what proportion of those costs is any particular tenant liable to pay towards? And thirdly, and this would be the point that I spend the most time on actually, what are the contractual procedures in any particular case which the landlord needs to follow to actually trigger liability on the part of the tenant as a matter of contract law? And they really are fundamental points because, as I've said, service charges are contractual rights. And it's not uncommon for me, and I suspect for my colleagues as well, to be instructed on service charge disputes, both for landlords and for tenants, where these fundamental basic points are really not thought about until quite late in the process. And then you realise actually quite a significant amount of money is not recoverable because a landlord hasn't demanded something properly. And if you're acting for the tenant, that's fantastic. If you're acting for the landlord, it's very embarrassing. So these are questions which I'm going to suggest to you really do need to be engaged with at an important level of detail and very early on in any service charge dispute. So I want to start with my first of those questions, and one of the cases that Tom cited to you was Arnold and Britton, and up until Arnold and Britton, there'd been various older authorities which suggested potentially that when you're construing leases, when you're construing service charge provisions, you might apply a different set of principles of interpretation to the meaning of those relevant contractual provisions. And Arnold and Britton firmly put that idea to bed. So when you're dealing with the question of what is a tenant liable to pay for under any particular lease, the simple answer is it all turns on the lease. And what the lease means turns on the normal principles of contractual interpretation, which are set out in Arnold and Britton. And generally, the court's task when you're thinking about the meaning of a contract is to try and work out what a reasonable person would understand the parties to have intended by the language that they used. So when you're grappling with this issue, what's the tenant liable to pay? What's the tenant liable to pay for? Common problems and questions you will encounter. Repairing and maintaining the building, that's an obvious one that the lease will provide for generally as a cost which the tenant has to pay for. But you then have a whole range of satellite disputes in relation to any particular expenditure. Is an item a repair, or is it an improvement? Oftentimes a service charge will allow repairs but not improvements. Was the building actually in disrepair at all? The standard of the repair, the quality of the work, which engages questions of reasonableness under Section 19. Other costs that are commonly provided for as a recoverable cost by the landlord are the costs of a managing agent. But then you can have issues about whether that contract's a qualifying long-term agreement. And if it is, have the correct procedures been followed? And if no, the costs of that are not going to be recoverable. Costs of insurance, another very common one that will be recoverable by a landlord. That's the first basic contractual question. What does the tenant actually have to pay for? And then, as Tom indicated, what makes service charges in the residential context particularly complicated is that there's then a statutory gloss on all of that, because even if a particular cost is contractually recoverable, it's subject to that statutory limitation of reasonableness in Section 19, which I think Tom will talk about, which is generally that costs have to be reasonably incurred. And if it relates to the provision of works or services, they have to be to a reasonable standard. That's costs. So once you've established what the tenant is actually liable to pay for, you then have the question of what proportion of those costs the tenant is liable to contribute to. And we can take this one rather more quickly. Generally, most leases will either provide for a formula in which provides for how the service charge is to be apportioned between leaseholders, or you might simply have a fixed proportion. It might be a fifth or something like that, generally proportionate to how many units there are in any particular building. And a lease may also entitle a landlord to change the apportionment in any particular case. One of the cases Tom mentioned earlier, of Aviva and Williams, resolved a controversy that was around for a few years about the extent of those provisions, whether they're valid, and what the extent of the tribunal's power was under Section 27A to review the landlord's decision. And the Supreme Court confirmed in that case that the FTT's role is limited to reviewing a landlord's decision to reapportionment. Their task is not to simply substitute what they think is the correct apportionment. Okay, contractual requirements, contractual machinery proper. This is where I'm going to spend most of my time now. So again, I keep banging on about this, but it really can't be forgot that a lease is a contract. And the lease will generally, as the Court of Appeal put it in the Leonora investment case, it will generally prescribe the contractual route down which the landlord must travel to be entitled to payment. And it's generally the case that the landlord will need to comply with those requirements to trigger the liability on the part of the tenant. And it's difficult to say anything as a generality, really, because every single lease tends to be different. But you might have, for example, a lease which has a contractual requirement that the landlord serve an interim demand halfway through the year, followed by a final demand at the end of the year, which reconciles the accounts, and that final demand is certified by surveyors and so on. It might have to be served at a certain time. The long and the short of it is that if there is a contractual route to triggering liability, the landlord needs to follow it. And it's not uncommon at all for disputes to go to the FTT on the basis that the landlord hasn't complied with the letter of the lease and therefore simply hasn't triggered liability on the part of the tenant at all. A couple of common issues you see on this. First one is that if a lease requires a tenant to pay towards certain costs incurred in a particular accounting year, generally the costs will need to be incurred within that year. And I did a case a couple of years ago involving a block where there were very substantial costs to the repairs to a roof. And I think from memory, it was almost £100,000. And the landlord lost. I was acting for the leaseholders, but the landlord lost principally on the ground that they couldn't prove that the costs had actually been incurred when they said they were. So it's, again, a fundamental basic point when you get a service charge case across your desk. If that's the type of requirement that's in your lease, the landlord needs to be able to prove they've complied with it. Another common one is end of year account to be certified by a surveyor. If that's a requirement of the lease, it needs to be complied with in order to trigger liability. And many of you, I expect, will have been involved in cases where things go wrong, because generally what keeps us all in work in the litigation context is when people make mistakes. So what happens? What can you do if something goes wrong? Well, generally, first question is time of the essence for the purposes of that particular contractual machinery. Generally, it won't be, unless the lease provides otherwise, but generally it won't be. So if it's not, the landlord can simply start again, serve the demands again, for example. Second argument you might want to look at is estoppel or waiver. So it's not uncommon at all for particular landlords in particular arrangements to effectively, for a very long time, just not comply with the lease and serve demands in a particular way. Custom of practice builds up, and someone eventually takes the point and says, "Hang on, you're not complying with the lease." Well, if that arrangement's been ongoing for some time, unchallenged, you potentially have got arguments about estoppel or waiver that you can employ in any particular case. Demands are a tricky area. It's the last point on contractual machinery that I want to focus on, and it's really a critical point. So first point to stress is that your demands as a landlord need to comply with the terms of the lease, but both as to the contents and the timing. And again, that turns on what the lease says in any particular case. But beyond that, there are actually four. I've not put the fourth one on here, but I am going to talk about it. There are four important statutory glosses which you need to bear in mind for the purposes of the validity of demands and whether or not liability has properly been incurred. First one is Section 20B of the 1985 Act, and that concerns timing. The short point here is that under Section 20B, a landlord cannot demand a service charge more than 18 months after the cost was incurred. So effectively a long stop date. It doesn't apply if the landlord tells the tenant within the 18 months of incurring the costs that they had been incurred and that the tenant will be required to contribute. But if that hasn't happened, the 18-month point is a strict deadline, and it's not uncommon at all to see landlords fail to comply with it. 18 months really not a long time in the grand scheme of things. Important to note, for the purposes of this provision, time runs from the date costs were incurred, and you can have disputes in any particular case as to when costs were incurred. It's not critically, costs are not incurred at the point that the services are provided to the landlord. A liability must crystallize before it becomes a cost, and that could be when the landlord pays. It could be when a demand is presented to them, but it's not simply the date the services were provided. Section 21B of the 1985 Act. So this concerns what your service charge demand as a landlord needs to have with it. So Section 21B subsection 1 provides that a demand for payment of a service charge must be accompanied by a summary of the rights and obligations of tenants of dwellings in relation to service charges. And the stinger in this is that a tenant, if this is not done, can withhold payment of the service charge which has been demanded from them for so long as subsection 1 is not complied with. And if the tenant has the benefit of this provision, the provisions in the lease as to forfeiture, etc., don't have effect. Summary of rights you can find in the statutory instrument that I put on the slide there. I think it's the I'm not going to say I think it's the only statutory instrument I've seen that prescribes the size of the font which the summary of the rights and obligations must be complied with. So next time someone tells you property law isn't interesting, just refer them to Reg 3 of the Service Charges Regulations 2007. Section 47 of the 1985 Act also concerns the nature of demands and what they must contain. So a written demand in any case must contain the name and address of the landlord in England and Wales, and if the address is not in England and Wales, an address in England and Wales in which notices can be served on them. And again, there's a suspensory effect on liability, because if the demand does not contain that information, the service charge should be treated for all purposes as not being due from the tenant to the landlord at any time before that information is furnished. Finally, section 48, very similar point. The landlord must provide to the tenant an address in England and Wales at which notices may be served on him, and the same effect applies. So long as the landlord doesn't do that, the service charge isn't due. That brings contractual machinery to an end, and I'm going to pass it back to Tom, who's going to speak on reasonableness.
Thank you very much, Dr. Ronan. I love to speak on reasonableness. Let me see if I have recovered control yet of the slides. Great, I think that I have. So my topic will cover two broad topics. My talk will cover two broad topics. The second of those topics is the statutory requirement that service charges be reasonably incurred. The first of those topics is about contractual obligations for a landlord to make decisions acting reasonably. For example, about the apportionment of service charges between tenants, which is something Harley briefly touched on. Now, importantly, those discretionary decisions about apportionment and the like sit outside of the statutory regime requiring service charges to be reasonably incurred. And contractual obligations like this have been the subject of a number of very important cases in recent years, and the law has in fact very substantially changed in a number of respects. And the easiest way to understand where the law now stands is to follow the story of its recent evolution. And we can begin that story with a nice quotation from a 2001 House of Lords decision. This is what Lord Bingham thought about the over-lawyering of the concept of reasonableness. So I respectfully endorse the observation of Viscount Dunedin in Viscount Tredegar and Harwood that one should view reasonableness in the general sense. There are few expressions more routinely used by British lawyers than reasonable, and the expression should be given a broad, common sense meaning in this context as in others. But nonetheless, the question of reasonableness in the context of contractual discretions has been the source of some real difficulty, particularly in the service charge world, because despite Lord Bingham's suggestion that reasonableness should be given its ordinary meaning, two very distinct notions of reasonableness have made their way into the service charge space. The first of those is Wednesbury unreasonableness, so called, or sometimes called rationality. And this is a public law concept which emerged in the context of judicial review in the 1948 cinema case of Associated Provincial Picture Houses Limited and Wednesbury Corporation from the judgment of Lord Green, the Master of the Rolls. It's sometimes called rationality by public lawyers, and here is a good explanation of it in the service charge context by the Deputy President of the Upper Tribunal in a case called Braganza and the Riverside Group. The requirement essentially is that a decision be made in good faith and not arbitrarily or capriciously, and it must be arrived at taking into consideration all relevant matters and disregarding irrelevant matters. So the standard here is a fairly low one, if it's a standard of rationality or Wednesbury reasonableness, and it is to be distinguished from what is sometimes called objective reasonableness. Frequently cited examples are obligations to arrive at a reasonable price or to determine a reasonable time. And this was explained helpfully by Lord Justice Ricks in a banking case, Sophie International and Standard Bank. The concept of reasonableness here is intended to be entirely mutual and thus guided by objective criteria. So the standard is a much higher one. It's more akin to a requirement of a fairness and achieving a fair outcome. And in a recent service charge case in the Upper Tribunal, Judge Cook said this about these two concepts. Those two different standards of reasonableness have been distinguished by referring to the narrower or limited standard as rationality, which is something of a relief, since much mischief is caused when the same word is used to describe two importantly different concepts. But like it or not, the public law concept of rationality or Wednesbury reasonableness has made its way into the law of contract. That is clear from a Supreme Court decision from 2015 in a case brought by a Mrs. Braganza, whose husband vanished over the side of a ship at sea, leaving his employer to decide whether his death was accidental. And this is what Baroness Hale said. It is clear, however, that unless the court can imply a term that the outcome of a decision be objectively reasonable, the court will only imply a term that the decision-making process be lawful and rational in the public law sense, that the decision is made rationally as well as in good faith and consistently with its contractual purpose. But after the decision in Braganza, the property tribunals have struggled to work out whether a lease imposing an express obligation to make a service charge decision acting reasonably imposes a higher standard than this so-called Braganza rationality. And as Harley said, for some time, the tribunals thought that landlords actually had no right at all to make any apportionment decisions because of Section 27A(6) of the Landlord and Tenant Act of 1985. There was a line of Court of Appeal cases, all of which had held that the effect of that subsection was to strike down a landlord's power to reapportion service charges and to transfer that function to the first-tier tribunal. And it took a while for those cases to be challenged in the Supreme Court, and they were recently challenged in the Supreme Court by Williams and Aviva investors. And there, the Landmark Chambers dream team of Simon Allison of King's Counsel and Brooke Lyne persuaded the Supreme Court not only that all of those Court of Appeal decisions were wrong, they even persuaded Lord Briggs that he himself, as Lord Justice Briggs, had been wrong in one of those very cases. And the decision in Aviva and Williams made clear that landlords can make discretionary decisions about service charge apportionment, and that the role of the tribunals is to review the contractual legitimacy of those decisions. And this was the wording essentially of the clause in Aviva and Williams. There was a contractual provision in the lease that provided for the tenant to pay a fixed proportion of common costs or such part as the landlord may otherwise reasonably determine. So there was a right that the landlord had to vary the apportionment provided they did so reasonably. And this is what Lord Briggs in the Supreme Court said of the jurisdiction. Said it is to decide whether a service charge demand is payable, and that will extend to the contractual and or statutory legitimacy of those discretionary management decisions. If the landlord's discretionary decision in question was unaffected by the statutory regime and fell within the landlord's contractual powers under the lease, then there might at most be a jurisdiction to review it for rationality. And he quoted the Supreme Court's decision in Braganza. Now that last sentence quoted there resulted in some confusion in the tribunals and led to a series of apparently conflicting decisions in the upper tribunal. So in Braganza, a different Braganza, a Dr. Braganza, against the Riverside Group Limited in 2023, the Deputy President, Martin Roger QC, suggested that the tribunal's role was limited in every case to a rationality review along the lines of Braganza. But in Hawke Investment Properties Limited and Eames, Judge Cook apparently took a different view. She said the tribunal was not constrained to a rationality review and that everything depended on what the contract required. And in Bradley and Abacus Land 4 Limited, Judge Cook then said that an obligation to act reasonably meant objective reasonableness in the sense explained by Lord Justice Ricks in the Sockima Bank case. Now, the Bradley and Abacus Land decision of Judge Cook resulted in an appeal to the Court of Appeal, which straightened out the law for good. And this was the clause in issue in Bradley and Abacus Land. The lessees had covenanted to pay such fair proportion as the landlord, acting reasonably, shall from time to time determine of costs which the landlord, acting reasonably, shall designate. Now, this was what the first tier tribunal said about this. This was a case which I first argued, in fact, in the first tier tribunal. And the facts of the case were very difficult. In fact, I'm going to go back so that we don't see yet what the first tier tribunal made of it. The facts were tricky. The landlord's predecessor in title had developed a building in Westminster and sold the flats on long leases, reserving a service charge. It then granted a 999-year lease of a gym in the basement to which all the leaseholders had access at a very low rent to a family member of the original developer to run a personal training business. But that 999-year gym lease did not require the personal trainer to pay a service charge. And all of the costs of refurbishing the gym at the personal trainer's insistence had to be put through the service charge of the leaseholders. And unsurprisingly, perhaps the leaseholders protested that that was not fair, and they brought a challenge in the first tier tribunal, saying the landlord had not acted reasonably in allocating those costs to them and that they didn't have to pay them. And so this is what the first tier tribunal concluded, essentially, that the landlord's decision was an unpalatable one from the point of view of the leaseholders, but it was not a decision which no reasonable landlord could have made, and therefore it was legitimate under the terms of the lease. Now, the leaseholders then appealed to the upper tribunal, and disagreeing with me, this is what Judge Cook said. Therefore, in my judgment, an express requirement in a lease to act, quote, reasonably in exercising a discretion refers to objective reasonableness. By contrast, where a landlord's discretion is unqualified, then the test to be applied is one of rationality only. Judge Cook allowed the leaseholders' appeals and said that the first tier tribunal had got it wrong, and this is her conclusion, again disagreeing with me. She said, if the first tier tribunal intended to apply a Braganza rationality test, it was wrong. If the FTT did intend to apply a test of objective reasonableness, then in my judgment it reached the wrong outcome. It is manifestly unfair and therefore not objectively reasonable for the leaseholders to pay the whole of the gym costs after 2020 when they no longer had exclusive use of the gym. So Judge Cook essentially quashed the landlord's decision, said it was not contractually legitimate because not made objectively reasonably, and she said the landlord had to go away and remake it. This time the landlord appealed to the Court of Appeal. And as I may already have mentioned, I acted for the successful landlord on that appeal, instructed by shout out to JB Leach Limited. Some of my instructing solicitors, I think, may in fact even be attending this webinar. This is what Lord Justice Nugent said about the jurisdiction. He said, the question for the first tier tribunal, as I have said, is whether the landlord acted in breach of contract. The landlord will have acted in breach of contract if and only if it can be said to have acted unreasonably or to have not exercised a reasonable discretion. What then is the limit of permissible decisions? And I do not think one can improve on the way it was put by Lord Justice Lewis in argument, namely that a decision is a permissible one if it is one that a landlord acting reasonably could reach. Or, to put it negatively, the landlord's decision will be flawed only if it is one that no reasonable landlord could have reached. And you will hear in that an echo of the conclusion reached by the first tier tribunal, which was restored by the Court of Appeal. And helpfully, perhaps, what Lord Justice Nugent said is that such a test accords with the long-established principles applicable to the question whether a landlord's consent has been unreasonably withheld. I do not think that any sensible distinction can be drawn between the question whether a landlord is acting reasonably in refusing consent or is acting reasonably in designating costs as a service charge item. And that is great news because there is, of course, a long established and stable body of case law telling landlords what they need to do in order to refuse consent reasonably. And there is, in fact, an excellent book written by Landmark Chambers' Miriam Sietler called Leases, Covenants and Consents, now I believe in its second edition, which sets out all of the relevant principles and should sit on every property litigator's desk. So thankfully, the law on reasonableness in the contractual context is now very clear, as is the extent of the tribunal's jurisdiction to review landlords' discretionary apportionment and management decisions. So the important slide then is, where does this leave us? What are the key takeaways for practitioners? And the first point seems to me is that the terms of the lease are critical. The landlord must act in a contractually legitimate way whenever it exercises a discretion. An obligation to act reasonably will import a fairly wide discretion akin to the Braganza rationality review, Braganza rationality discretion. But there is a distinction to be made where there is a stipulation for a particular outcome, such as an obligation to determine a fair proportion or to use a just and equitable method of reapportioning service charges. If the lease stipulates that the outcome must be fair, then that is going to be more constraining in point of contract law. So clearly, landlords need to make sure that they are keeping clear records of why they have made a particular decision about apportionment and the basis on which the decision was made. And the more stringent the contractual stipulation, the clearer those records need to be, because the higher will be the landlord's burden of demonstrating that what it has done complies with the terms of the contract. That is especially the case if there is a contractual requirement to achieve a fair outcome. So having told then the story of the recent litigation over contractual reasonableness, now turn to the second part of my talk, which is happily a much older story, and that is the statutory requirement that service charges are reasonably incurred. That requirement is well known. It is currently set out in Section 19 of the 1985 Landlord and Tenant Act, which is well known. It is on the screen. Happily, as I've said, the law in this area is rather more settled. The requirement that service charges be reasonably incurred was explained helpfully by Lord Justice Lewison nearly 10 years ago in a case called Waller and Hounslow LBC. And what Lord Justice Lewison explained is that whether costs have been reasonably incurred is not simply a question of process, it is also a question of outcome. And what this means is that the landlord needs to do two things. It needs to adopt a reasonable process when deciding what to do, and it needs to adopt a reasonable course of action. In other words, both the decision-making process and the outcome must be reasonable. And it has more recently been established by the Court of Appeal at the end of last year in a case I mentioned earlier, in which Simon Allison, KC and I acted, that the same approach to a one-off cost is to be applied as to repeat payments under a long-term contract. So that's the decision in Spender and FIT Nominee Limited 2025. Now, what does reasonableness then mean in this context? This is what Lord Justice Lewison said in his judgment in Waller and Hounslow. So it must always be borne in mind that where the landlord is faced with a choice between different methods of dealing with a problem in the physical fabric of a building, there may be many outcomes, each of which is reasonable. The tribunal should not simply impose its own decision. If the landlord has chosen a course of action which leads to a reasonable outcome, the costs of pursuing that course of action will have been reasonably incurred, even if there was another, cheaper outcome which was also reasonable. And in considering whether the final decision is a reasonable one, the tribunal must accord the landlord what, in other contexts, is described as a margin of appreciation. As I have said, there may be a number of outcomes, each of which is reasonable, and it is for the landlord to choose between them. Now, one thing that emerges from the Spender and FIT decision is how reasonableness is to be determined by the first tier tribunal in practice on applications under Section 27A of the 1985 Act. And the Court of Appeal helpfully summarised the approach. So a landlord, starting point, will not have to justify each and every element of service charge claimed from the tenant. There is a burden on the tenant to identify, and indeed to plead, the costs that it says were unreasonably incurred. The landlord will only have to demonstrate that those costs were reasonably incurred if the tenant is able to establish a prima facie case that they were not reasonably incurred. if the landlord cannot discharge the burden of proving reasonableness where a prima facie case is demonstrated, the tenant will win. So in other words, the tenant has to raise a prima facie case. If it can do that, then the burden, to use the burden of proof terminology, shifts to the landlord in order to demonstrate reasonableness. If it can't do that, then the tenant wins. Now, there are some general points that it's worth keeping in mind about reasonableness under Section 19. The first is that, in general, the reason why works are needed is irrelevant to reasonableness. So what this means is that if, in fact, works are needed to a property because a landlord has breached its obligation to do something, the fact that the works are essentially the landlord's fault is irrelevant to the question, are the costs of the works reasonably incurred? The tribunal looks at the circumstances at that point in time. An authority for that proposition is Continental Property Ventures and White from 2006. There's a line of cases which follow that. And what they say essentially is that to the extent that the landlord has done something wrong and breached an obligation, the tenant may have a claim in damages against the landlord for breaching its obligation. And what the tenant can do is to say to the tribunal, I have a right to set off the landlord's liability to pay me damages against my liability for service charge. So in other words, you arrive at a point where the tenant doesn't have to pay what the landlord has essentially caused through its own neglect to need to be paid. But that is not through the analysis of reasonableness. It is done through this set-off technique. But keep in mind that the upper tribunal took a slightly different approach in Radcliffe and Meeson, which was an upper tribunal decision which I lost in front of the deputy president. There, the landlord, what was an issue was the cost of a waking watch. And the landlord had caused the waking watch to be needed because it had failed to comply with its own obligations in relation to fire safety in the building. And what the upper tribunal said was, distinguishing Continental Property Ventures and White, that it was nonetheless unreasonable for the cost of the waking watch to be incurred. So there is some tension in the authorities there at upper tribunal level, which is yet to be resolved by the Court of Appeal. Next general point to keep in mind is that where works could have been done at no cost under a guarantee, the starting point is that the costs will not be reasonably incurred under Section 19 and the tenants won't have to pay them unless the landlord can show that there was a really good reason to reject the no-cost option. Another general point to keep in mind is that reasonable does not mean cheapest. That's clear from Lord Justice Lewison's judgment in Waller and Hounslow. And again, keep in mind that a landlord is to be given a wide margin of appreciation. The tribunal cannot simply substitute its own view because it thinks that the landlord should have opted for something else if that other thing was also reasonable. In other words, the tribunal should not make itself the decision maker. Again, that comes from Waller and Hounslow. So again, coming on to the important bit, practical tips, first of all, for tenants. What tenants must do when they are engaging in service charge litigation with their landlord is to identify clearly each charge which they are challenging. And then need to explain in general terms why they say that the charge that they are challenging is unreasonable. They need to do this in order to discharge the burden of raising a prima facie case. And they also need to try to evidence why it is that that is unreasonable, because there is some authority at upper tribunal level that tenants cannot simply put the landlord to proof of reasonableness. They need to do more to put in evidence to raise a prima facie case. And usually that requires some evidence to show that a particular cost is out of line with market norms. That is something that tenants ought really always to try to obtain on a Section 27A challenge. And then finally, coming on then to practical tips for landlords. In light of the recent spate of cases about contractual discretions, it is clear that landlords, whenever they're having to justify things, need to keep clear records of the decision-making process that they've undertaken whenever they are looking at carrying out works. They should also consult the tenants, and Sophie Gibson is about to explain what the consultation requirements are, so I won't say anything more about that. They should also tender for works wherever possible so that they can demonstrate that they've carried out a competitive exercise, they've tested the market, and they can show that the costs that they've incurred are reasonable and in line with market norms. They should also try to keep records which are sufficient to justify why a particular option was chosen. Where feasible, it seems to me, landlords should try to rely on advice from surveyors. So unless they are a large institutional landlord with surveyors and sufficient expertise in-house, they should try and contract that out to make sure that they can say they were always acting on professional advice. And where you're an institutional landlord with your own, quotes, panel contractors, you need to be able to justify the reasonableness of just getting a panel contractor to do so, and anticipate the possibility of a tenant popping up and saying, well, had you not gone to your panel contractor and gone out to tender, it would have cost a lot less. And critically, landlords need to make sure that they can meet reasonableness challenges with detailed evidence explaining both the reasonableness of the decision-making process and the reasonableness of the outcome, nor do they need to try to address both limbs of the Weiler and Hounslow test. That is all I have to say about reasonableness. So I'm now going to hand over control to Sophie Gibson, who is going to talk about the consultation requirements.
Thank you, Tom. And so, yes, I'm going to talk about consultation, what it is, when do I have to do it, why do I have to do it, how do I do it, and oops, I've not done it. What next? First of all, consultation, what is it? It's essentially a process set out by statutes, regulations, and schedules that requires landlords to consult residential tenants before certain works are carried out or agreements are entered into, and provided that certain contribution thresholds are met, essentially to make sure that tenants get to have a say in what happens to their building. And then the framework for this comes from the 85 Act, from sections 20 to 20ZA, and the main section you'll see is 20 subsection 1. So the section applies to any qualifying works and qualifying long-term agreements. Those are the key triggers here, and I'll address in this webinar what those words mean. If it applies to the qualifying works or qualifying long-term agreements, the relevant contributions are limited unless the consultation requirements have been either A, complied with, or dispensed with. Those are your two main gateways on satisfying consultation. And if they're not, then contributions are limited. So then, more regulations. These ones are not the exciting ones with the font requirement, as explained by Harley. These are other regulations. These are 2003 service charges consultation requirement England regulations, or 2004 Wales consultation charges regulations. And this talk will be mainly directed at private landlords, but if you are acting for a public landlord, then there's a different procedure involved. And you should pay attention also to the regime under the Procurement Act. So then, who needs to consult? Now, the section is confined to landlords. So landlords are the ones who need to consult. And there's a definition of who a landlord is under section 30 of the LTA. And it's defined as including any person who has a right to enforce payment of a service charge. And there was a relatively recent decision of Judge Cook in the RM residential case, and the citation is on the slide. This includes a landlord in the registration gap. So in that particular case, there was an incoming purchaser, someone bought the freehold, the building was an estate, it needed a lot of major works doing to it. The purchaser didn't consult, the works were deemed to be too urgent, and then the tenants complained that because there was no consultation process carried out, they couldn't recover, but in any event, they weren't the landlord. They weren't able to apply for dispensation. Now, the FTT said, that's entirely correct. Until you're the legal title holder, you are not the landlord, so you can't apply for dispensation and therefore you can't recover any money, well, above the statutory threshold. And the upper tribunal, Judge Cook, said, no, that's wrong. In the registration gap, the incoming purchaser is entitled to carry out the works, entitled to enter the property, and they are entitled to enforce the payment of a service charge. So under the statute and also under general principles of the registration gap and the purchaser constructive trust, then they are also a landlord able and required to consult and or apply for dispensation if they don't consult. And likewise, this definition could include a management company if they have the right to enforce the payment of the service charge, or if they are just simply acting as a landlord's agent in the usual way. And if there is an RTM company, that is a right to manage company under the Common Hold and Leasehold Reform Act 2002, the person who needs to consult is that RTM company. And that's because of the schedule to the 2002 Act. Additionally, a superior landlord might need to consult if they are the one that's planning on carrying out the works or entering into the agreement. But unlike with your simple landlord and tenant direct relationship, they need to consult both the intermediate landlord and each individual subtenant of the dwelling who will be the one contributing. And it makes sense because the requirement is there to ensure that the person at the end of who's footing the bill has some say in the process. And then the authority for that is the Foundling Court, and O'Donnell Court decision with the citation is on the slide for you. So then, what happens if I am a landlord within Section 30 and I haven't consulted? You're still allowed to go ahead and undertake the works or enter into the agreement, but you won't be able to recover more than the statutory limit in terms of the cost of going ahead and doing those works or entering into those agreements. And that cap is £250 per tenant for qualifying works and £100 per tenant for every 12 months for the qualifying long-term agreement. And this amount is set by regulations and it hasn't increased with inflation. So I'd be really careful about not consulting if you are required to, because that can really hinder the landlord's means to pay for the works out of their own pocket. And also, if you don't consult, practically speaking, consider and or make an application for retrospective dispensation from the requirement to consult in the first place, to which I shall turn later on. And now, when do I need to consult? Well, you need to consult if you plan on carrying out any qualifying works. And qualifying works, I'll go into more on the next slide. This is just an overview. You need to consult if you're going to enter into a qualifying long-term agreement where any tenant's contribution will exceed £100 in a 12-month period. And if there's a combination of the two and you're doing works, but there's also a qualifying long-term agreement already in place, you still need to consult, but there's a different process, and that's set out in Schedule 3. Now, the meaning of qualifying works. These are very helpfully defined as works on a building or any other premises. And the definition can be found in Section 20ZA2 of the 85 Act. And again, very helpfully, neither the 85 Act nor the regulations define what works are. I mean, sensibly, they can range from day-to-day repairs to planned maintenance to major improvement works. I mean, a classic one might be there's a hole in the roof and you need to fix it, and it's going to cost quite a lot of money to do that. But there has been some case law on working out what works actually means, as it's important to determine whether or not the trigger of consultation applies, and if it does apply, what happens if you haven't done it. I mean, there's two cases there on the slide. I mean, the Francis case was to do with a caravan park in Cornwall. Now, the Mr. and Mrs. Francis had bought the park, did various bits of work to the park, but didn't consult and yet sought to recover the cost of that from the service charge. And the tenants argued that the work should have been considered as a whole in one big chunk, which would have taken it above the threshold and they should have been consulted on. The Court of Appeal said that that wasn't correct. You should look to what is one set of works and see if that amounts to qualifying works and that exceeds the threshold. And likewise, the Paddington Walk management decision there, that held that other services, unsurprisingly, such as window cleaning, gardening, and other cleaning are not qualifying works. But I suggest that you go along and have a read of those decisions if you're trying to work out, does this apply to me? Next, then, a qualifying long-term agreement. So compared to works, works are doing often one or two things to the property, whereas an agreement is entering into some sort of contract. And then the QLTA, as it's known, is defined in Section 20ZA3 as an agreement entered into by or on behalf of the landlord or a superior landlord for a term of more than 12 months. And there are certain exceptions to this, so you need to check whether or not there is a contract for more than 12 months, but nevertheless, it is accepted by Regulation 3. And so it's been held in various decisions that the important question here is the term of the contract. Is it a minimum of 12 months? Yes. Then it's likely going to be a QLTA. And that comes from the Corvan decision. And in that case, there was an agreement which provided that the contract period will be for a period of 1 year from the date of the signature hereof and will continue thereafter until terminated upon 3 months' notice by either party. And then the use of and will continue introduce a mandatory requirement that the agreement continue beyond the initial 12 months. So if it's going to go on more than 12 months, then yes, it is. However, then there was the Bracken Hill Court decision in the UT when there was another set of an agreement, and it did happen to be renewed year to year, but it still wasn't a QLTA. And the fact that historically it had been renewed like that didn't mean that it was required to be like that. And so an expectation that it would be renewed annually and go on for longer than 12 months isn't the same. So some examples here then of some QLTAs or some qualifying works. One example of a QLTA would be a 2-year contract to manage a block with 100 flats quoted at 20 grand per annum. I hope that my maths there is correct, because the threshold here is that if it's going to be over £100 per tenant per 12 months, then yes, it will be, provided the term condition is met. And so here it has been, it's over 12 months, it's a 2-year fixed contract, and then yes, each tenant's liability will exceed threshold. Next then, a one-off inspection by a building safety expert to assess whether the tenants of the building need to have an EWS1 to buy or sell their flats. That looks to the BSA 2022 to work out the thresholds there. If someone's rocking up one time, it's not a contract for a term of more than 12 months. It's just a one-off time, so that wouldn't qualify regardless of the cost. Finally, qualifying works, fixing a lift, going to cost 10 grand, and it's 10 tenants. So that would be £1,000 each, which would over the £250 threshold. So it's both a mixed mathematical and legal question. Now then, how do I consult? We've got when do I consult, who needs to consult, what works and what QLTAs do I need to consult on? Now, how? Now, the regulations, both the England and the Wales ones, are very prescriptive. You need to have a copy of these and cross-reference that with your various stages and the particular agreement or works you're going to enter into and whether you are a public or a private landlord. And then there's the regulations, but the regulations have got schedules to them, and it's a bit of a minefield navigating them. But each schedule relates to a particular type of agreement or part of a schedule, to type of agreement or works, and the identity of the landlord there is important. Now, the most common ones for private landlords is for works, is Schedule 4, Part 2, and the QLTAs is Schedule 1. But I suggest you go and have a good read of these yourselves. But in this slide and the next slide, I'm going to give an overview of some of the common stages which apply in these schedules. Again, this is just very high level. There's lots of nitty-gritty in the regulations themselves, but they commonly loosely fall into these 3 stages. Now, first, there is the notice of intention. It is what it says on the tin. It's a notice setting out an intention to enter into a QLTA or to carry out some works. You should explain why. It should be in writing, and you should invite the receivers of your notice of intention to give their observations to you within the 30-day period. You should invite the recipients to nominate their own contractors and state how and where documents relating to this process can be inspected. You should give an address for service, and then you should serve this notice on each tenant and any recognised tenants association. And then the next stage, you should go out and get estimates, including from any tenant-nominated contractor. Now, that's really important. It's going to raise eyebrows and prompt questions if you don't even try and reach out to the nominated firm by the tenants. It might be that they don't respond in time. I've had that before. They didn't respond in time for us to consider their tender. But you should at least ask them. And then you should provide an estimate or a statement summarising the estimates or proposals, each tenant's contribution, what you think they're going to have to pay, and invite more observations. Then you have stage 3, but stage 3 only applies if the landlord hasn't chosen the lowest tender or the nominated contractor by the leaseholders. And then there's another notice to be served within 28 days of awarding the contract to the nominated party. And the landlord should explain why they've chosen that and summarise the feedback they've received from the leaseholders hitherto. Now, there's no specific provision relating to services of notices under the regulations. So frequently you have a section or a paragraph or a schedule setting out how to serve if there's any deemed requirements or any requirements as to form. Now, the regulations don't have those. So there's your normal rules of service here. If there is a deemed service clause in the lease, you might want to avail yourself of that so that the risk is no longer on yourself. If there is a mandatory service requirement as to form or mode in the lease, then keep an eye on that to make sure that you comply with it. And in any event, you should always keep evidence that you have served the people that you intended to serve. So then practical tips mainly for landlords, but tenants should be looking out for the landlord failing to do this. Keep records. Keep records of your notices, the observations, all emails from tenants, all emails, no matter how irrelevant you might think they are, keep a record and know where to go and get them if you need to prove that you've taken them into account. Keep proof of service. If anything changes, if you suddenly realise that the lift is more broken than you thought it was, or actually the hole is smaller in the roof, it was going to require less time and less money, then you might need to go through the whole process all over again. So keep checking that what you're consulting on and what you've tendered is what's going to actually be implemented. And similarly, linking back to the Court of Appeal decision before, don't try and split one project into various mini projects so as to try and avoid the thresholds being brought into play, because that won't work. Next, dispensation. So I was meant to consult and I haven't, and now I am being restricted to the statutory cap. What do I do? Well, you make an application for dispensation from the consultation requirements. You're essentially saying, yes, I haven't done that, but I haven't, so how can we deal with this? Did it really matter? And your submission will essentially be no. And your answer is no, because the test is, have or will the leaseholders suffered relevant prejudice? Now, you can make an application prospectively. Well, you can say, I'm not going to get round to complying with these consultation requirements, so I'm going to apply now to the FTT for dispensation. Or you can apply having already done the works or entered into the agreement. And the test from this comes from the Supreme Court. It's the Dijan Investment Limited and Benson decision, and particularly Nord Neuberger at paragraph 44. And that the purpose of consultation is to ensure that tenants are protected from paying for inappropriate works or from paying more than would be appropriate. So the main question then on any dispensation application is what, if any, prejudice has been suffered by the leaseholders caused by the failure to comply with the requirements. Now, dispensation should not be refused solely because the landlord seriously breached or departed from the requirements. And it is still possible for a landlord who deliberately decides not to follow them to still obtain dispensation, and because the test is relevant prejudice. Now, what's not the test is the urgency of the works or the agreement. It might be the background, but not the test. For instance, if you have got a faulty fire alarm and there's some cladding that needs to be remediated, it's not an argument that you didn't consult because it was really, really urgent to get a new fire alarm and it was going to cost a lot of money. That provides the background context for your application. You should be focusing on the lack of prejudice you say that has occurred despite your failure to comply with the requirements. Similarly, what's not the test is reasonableness. Unless arguably there's some interaction with financial prejudice. So by this I mean reasonableness and the matters discussed by Tom and by Harley earlier this evening. If a tenant said, well, the work's too expensive because you didn't choose our nominated contractor who was cheaper and you didn't explain why, then that might make reasonableness relevant. But generally, it is just financial prejudice. Coming on then to this slide, there's some applicable case law provisions for you. Now, the burden is on the tenant to establish prejudice, a bit like with the reasonableness inquiry, and then it's for the landlord to rebut that once the prima facie case has been put. And that's from the Westminster City Council decision there. And the question then is, what, if anything, would the leaseholders have done differently if a consultation had been completed? So it's trying to join up in some sort of causation between the alleged prejudice and the breach of the regulations. And prejudice has to be financial. It's not simply, I lost the chance to have my voice heard. You have to show that there was a distinct financial prejudice that linked from that. Furthermore, dispensation can be subject to any conditions. For instance, you're granted dispensation, but certain costs are not recoverable from the tenants for whatever reason, and then the condition has to link back to the financial prejudice. So they may only be imposed where it's appropriate to do so, and where it would be reasonable to grant dispensation only if the landlord accepts certain conditions. And there's got to be the constant linking back, and that's from the Dijan decision. Furthermore, there's the holding and management solitaire limited and leaseholders sovereign view case with Judge Cook, that conditions must be relevant and appropriate, and relevant conditions address relevant prejudice. Again, it all comes back to prejudice and financial prejudice. Some practical tips and procedural matters on dispensation. The application is to the First Tier Tribunal Property Chamber, residential property, it's not to the county court. There's a prescribed form online that should be used by the landlord, leasehold form 5. After that, there'll be some directions from the tribunal setting out a requirement for a statement of case. And in that, you should set out all the steps that you've been taken. So this is when you draw upon all the evidence that you should have been keeping throughout the process. And even if you've not got formal evidence of your compliant notice of intention, have you put out a message in the building WhatsApp about what's going on? Have you said to anyone, do you want to nominate a contractor for these works or for this agreement? Has there been anything on a notice board saying let's have an informal residents meeting in the lounge on a particular day? Try and show what you have done. For instance, if you've complied with stages 1 and 2 but not stage 3, then detail 1 and 2. And if there is a report from a surveyor saying that works have to be done, then that doesn't hurt. And then the tribunal will consider the statement of case, consider giving any further directions, and you can either have it determined on the papers or at a hearing. If you've asked for it to be determined on the papers and nevertheless the tribunal calls a hearing, consider why that might be. Are there any gaps in your evidence? Are there any questions left unanswered? Are there any stages of the regulations and the requirements that you haven't complied with? Think about whether or not your application on paper gives enough detail and what you therefore might need to supplement at any hearing. And often hearings are virtual because it makes it more easy for leaseholders to join in. And that can be easier for all involved in terms of practical matters, getting to and from the FTT as well. And that is the end of both my consultation presentation and all of our planned presentations tonight. So returning now back to Tom to chair our Q&A session.
Thank you, everyone who's contributed some questions through the chat box. We'll spend a little bit of time going through as many of those now as we've got time for. The first question is, can a former tenant bring a tribunal claim challenging unreasonable service charges after they have sold their property? Sophie, we were discussing this earlier. Is this one that you could answer?
Just trying to scroll back up in the chat to see our conversation. Right.
Well, I'm happy to answer it then, if
Thank
that's
you.
it. So, Section 27A of the Landlord and Tenant Act 1985 provides that an application can be made by any person liable to pay a charge. So, if you're a former tenant and you haven't paid something that fell due when you were a tenant, then you can apply under Section 27A to the tribunal, notwithstanding the fact that you've sold the interest in your lease. So, the answer is yes. And the next question, Harley, can I punt this one off to you, given that it sort of touches on contractual issues in the first tier tribunal about a managing agent refusing to provide a telephone number and charging for every email sent and received, despite already applying a £200 management fee per property and has charged a substantive administration fee. How do you think the tribunal is likely to view this?
Yeah, 2 points occurred to me when I read this. The first one is there a right in the lease for the landlord to charge for the cost of a managing agent at all? So I don't know who the questioner is, but the question seems to be put on the premise that there is such a right. But just double check that, because it's not always the case that the lease provides for an express provision allowing the landlord to employ a managing agent. Sometimes there's sweeper clauses which you can try and rely upon in the absence of that. But that was the first thing that struck me. Second point that struck me then on how the FTT would view it. It's right to say, I think, generally that the FTT is a leaseholder friendly tribunal, but both in kind of substance and procedure. Certainly, procedure it's designed to be user friendly, but in substance, it tends to be on the leaseholder side. It has its origins as the leaseholder valuation tribunal and fair rents and things like that. I don't think a tribunal judge would take a particularly positive view of this. I can't see an obvious reason why a managing agent should not give a phone number to a leaseholder. Query though whether if there is a right to charge for the managing agent's work, why an email can be charged and a phone call couldn't be charged. So would it actually make any difference if there was a phone number? But in principle, I think a tribunal judge is going to take a pretty dim view of it. But yes, I think go back to the lease in the first instance, just double check there is such a right.
Thank you. There's a question, what is the typical course of action where service charges, although stipulated in the lease, are not recovered by the landlord, particularly where the building is falling into disrepair? So as I read that, the situation is that you've got a landlord which isn't in fact doing its job as a landlord and operating the service charge machinery and keeping the building fixed. The answer, it seems to me, is to apply for an order for specific performance against the landlord, that it carries out its repairing obligations, and an order for an application for an injunction requiring the landlord, if it needs to do so, to operate the service charge machinery and discharge those obligations in the lease as well. Often you will see in a lease an obligation on the landlord when asked by the tenant to enforce the tenant's obligations in other leases of the same block, which might provide another route, the sort of Duval clause, to getting the landlord or compelling the landlord to do its job and call the money in. So that, I think, is the answer there. There is a position about a sort of question about a mixed tenancy building. What is the position where the council has a secure tenancy and there are long leaseholders? Would the service charge to a common part of the building, e.g. stairwells, only be payable by the long leaseholder and the rest is with the council landlord? The answer is it depends on what the lease says. So read the lease, that determines the bargain between the parties in respect of that block. And then there is a question of qualifying works. This might be one for you, Sophie. Require listed building consent or planning permission. Is there a requirement to consult on the cost of obtaining that permission?
It sounds to me like all of those extra consultation on the cost of getting that permission and getting the consent or planning permission, it seems to be all part of the package of those works. So if that all taken together would be above the threshold, then I'd say yes.
And so, do you want to say you want to answer the next question about the QLTA?
Yes. So if the QLTA is for a term of 2 years but has termination provisions, is it a QLTA? I guess is the question. If they are locked in for a minimum of 12 months, then I would say probably yes. And if they're required to go over 12 months, then definitely yes. But if the break is only say 18 months, then yes, it would be. But if it's provided for sooner, the question is, are they going to have to be in there for 12 months or more? If yes, then yes, you have to consult.
Yes, yes. Could you do the next two questions as well, Sophie, about consultation? So the first is there a time frame within which the landlord should move on to stage two after stage one is completed?
Yes, there is a time frame, I believe, and it's in the regulations somewhere. It depends on which schedule you're in, what sort of works or agreement it is, if you're a public body or not a public body. So there is, and I suggest that you look to the particular regulations and the particular schedule.
Or alternatively, instruct Sophie Gibson to look at it for you and tell you the answer. And the next question on that is the consultation process different for a mixed use building where it's commercial and residential? Sorry, Sophie, I was seeing if you might be able to answer that, hence my silence. It's at 6:04.
Different from mixed use. Well, the regime only applies to residential property. I'm unsure if there's a particular threshold that applies within there, but we're talking about residential service charges. I'm unsure if there is a particular in a floor space limit, but there probably is. Maybe Tom or Harley might have more of an insight.
Seems to me that you're obliged to consult only on whether there's a residential lease. So if it's mixed use, you simply consult the resi tenants and you can ignore the commercial tenants, for they have no right under statute to be consulted. I think it's the short answer, isn't it? And then on consultation, if works are to be carried out over the threshold but not consulted, can a U-turn be made to separate each element of the works to ultimately fall below the threshold to avoid consultation? That might be something you touched on in your talk, Sophie.
Yes, I think that doesn't sound like it should be done. It looks like there might be a retrospective trying to artificially separate into smaller chunks when actually there's been one whole set of works, and works are to be looking at their particular sets. So I don't think that U-turn can or should be made.
Again, that sounds like one of those very fact-sensitive questions on which Sophie Gibson should be instructed to provide a detailed advice. There's a question then about reasonableness, which is, are the authorities on reasonableness from a contractual perspective in long-term leases, the two lines of argument leading up to abacus land, applicable to commercial lease service charge disputes? The simple answer is yes. The principles apply to any contract where there is an obligation to do anything acting reasonably. So the interesting thing about abacus land is it's one of those service charge cases where the law of contract is being nudged along in general terms by a service charge dispute. Harley, did you have a chance to look at there's a question about section 60 of the Land on Tenant Act 1987. I don't know if you managed to have a look at that.
I haven't, and it looks
3 paragraphs, so that's
quite
kind
long. Maybe one of those things that can be followed up outside of this webinar.
The question is also getting quite long. So there's one here. If within the part of the riverfront estate, river wall maintenance is imposed onto the leaseholders by the lease, even though the marina itself is sold to someone else, is it something that the leaseholders can challenge in the FTT? Well, that's interesting.
I can ask that one, I think. I think, doesn't that depend on who the landlord of the wall now is? Because the service charge will be a contractual obligation to pay the landlord's costs of repairing this wall. So if the wall is now sold to someone else and that someone else isn't the landlord under the lease, then I think the answer is, well, no, that person can't cover from the tenants the cost of maintaining it. And if the landlord is purporting to demand those costs, depends on what the lease says, but query whether they're recoverable by the landlord anymore now that they don't own that property.
That sounds like it must be correct in principle to me. And I think so. There are a couple of other quite long questions that I haven't quite managed to get my head around. So I think if your question has not been answered by any of us satisfactorily this evening, then I would urge you formally to get in touch if it's a question to which you need an answer. But otherwise, I think unless there are any other quick, short questions now, it's probably time to bring things to an end. We'll save that as a follow-up question on your landlord or a follow-up point on your marina, which is that if the landlord is different from the current owner of the marina, then I'm not sure what business the landlord would have trying to recover charges through the lease. It sounds quite complicated and fact-specific, and again, one to be looked at perhaps more thoroughly in a different context. So unless any other short questions which come in very shortly, I propose then that we bring the webinar to an end. Thank you very much, everyone, for coming. I think you'll get the slides sent out at some point tomorrow, and a link to the recording will also be sent out. And of course, it goes without saying that we are here in general, as are all our colleagues, to be instructed on these sorts of disputes. We do them all the time. I like to think that we're very good at them, although I was slightly despaired when Harley said that the first tier tribunal was a tenant-friendly tribunal, because it seems that every time I go there and represent a tenant, I lose. So perhaps that's not quite such a universal experience, Harley, but there we go. That's what the Court of Appeal is there for, I suppose.
Must only be when I'm there representing the tenants.
Great. Well, I'm going to end the webinar. Thank you very much to everyone who's attended.
Thank you.
And have a lovely rest of the evening.
Thank you, Tom. Good night.